Well, welcome everyone. To start with, I wanted to let you know that I was very pleased with your threaded discussions, how you posted those, and everyone got the concept and how to do it. Doesn't have to be extremely challenging, just fit that legal guidance, give some actions, and you have it pretty well identified. And you did a pretty good job with the board policy reviews. A few of you used some of the board policies that I gave you, which was okay. I would like for you to be knowledgeable of your own school's board policies, though. So you might want to take some time and look at those kinds of things. It wasn't until this morning, Carissa let me know that there was a problem in seeing the objectives and the activities for Modular 4. And at first we weren't sure what the problem was until I went back and checked. And lo and behold, because of Blackboard Ultra, told you there would be some glitches along the way. It didn't automatically let you see it. I had to click on and give you access to that. So I'm sorry that happened, primarily because this particular lesson provides a lots of background resources that will be very useful to you. Tonight, we're going to forge forward, and I will highlight those most important, particularly cases that have changed our direction in education. So we'll start out with looking at Modular 3 objectives, and if you have your study sheets, please get those out. And of course, the first area that we talk about is understanding best practices and the steps in staff employment, with a rationale for each step, including legal sources that support hiring practices. And I'd like to start out by just having you each give us a little bit of your background in your employment, how you were hired, anything along those lines. And Ezra, why don't you start us out?
Okay. So I was hired a year ago at my current building, fresh out of college. I had been looking for a job. But as a first year teacher, it was hard to find one. So I had applied originally at my building to be an English teacher because I'm certified in English and history. They couldn't fill because of enrollment the English job, but they did call me back about maybe a week before the school year started and said, "Come teach advanced placement government." And I said, okay, I guess I'll do that. Hadn't, been in a government class since junior year of high school, but there I was.
The rest is history.
Yes,
Yeah.
literally.
And so, one of the things you point out there is that certification in your parochial school, and certification is a little more lenient than it is in a public school. And so you were beneficiary of the lenience of that certification.
Yeah, I was wrapping up my history certification as I was being hired. I was taking the test. So
Good, good. Oftentimes, individuals don't have particular degrees in religion, but are often hired to teach religion. How about you? Tell us your path.
So for me, actually it was in 2020. I was still overseas in Lebanon and I knew I was moving to the US. It was COVID year. So I was just submitting applications, and then it was that same night that I got a message saying that they're interested in my resume and they'd like to interview me. So it was a very quick process. I had landed my job before even coming to the States. My contract was already signed. In terms of my certification, I told them that I was working toward it. Like, I knew the process of the certification and how I would need it. And then I eventually passed it, and here I am.
And my guess is that was on Zoom. You probably were interviewed on Zoom and those kinds of, and, for a presentation here that I gave you, we are looking at more of a traditional sit down type of interview process. Although there's nothing wrong with it being done via a Zoom. The only thing is, you still have to consider those legal accommodations, things such as that. Okay. Nawal?
Hi. So I was hired with Durham Public Schools. I applied on the Wayne Risa website. And then after a while, I got a call from different buildings and I went for interviews. At the interviews, they had at least like 6 to 8 people. sitting, asking questions.
So
And
you had,
then
you had a panel interview. Okay, good.
yeah, panel interview, and then you have to teach a lesson plan or a lesson. So you have to have a lesson plan ready, teach a lesson, and you would just wait from one interview to another, and then you would get a call from HR.
Each of these persons interviewed you separately, as opposed to,
So each school.
oh, each school. I got you.
So I applied at Wayne Risa, and it asks what public schools do you want, or what schools do you want, and it sends your resume and everything.
Yes.
And then every school gets that within the district, and they call you to interview you. But then you have the first interview and you present them with the lesson plan. And then the second interview, you have to, if you make it, you have to go implement it in a classroom. And then third step is wait for HR. If they're interested, they'll call you with an offer, and then you go there. So, yeah.
And you get an offer and you sign the contract.
Yeah.
Yes. Yep. Angela.
I obviously just went through my interview process, and mine was very interesting because school had actually, the teachers had already reported. I had applied on the Wayne Risa website for my job. The teachers had reported. They called me the third day of professional development, had me come in. I did a panel interview.
Was this the first time you had ever gone through a panel interview?
No, no, because I had been interviewing all summer, and I've interviewed in the past for other jobs.
So that was pretty common practice for you.
Yeah, this isn't the first time I've tried to leave my Catholic school. But so then they called me and said that they were interested, and then they had to check my references. And they checked my references. The principal formally offered me a job. Then HR called me and formally offered me the contract. And then I reported to school the following Monday to start the following Tuesday.
Pretty quick process.
Yeah, 5 days.
Teresa.
So I actually interviewed for the school that I've been at the whole time and am currently still at 6 months after I graduated college, and that was in June of 2004. And I was then I was interviewed by the dean of students because they were going through, their principal had retired, and they were going through the process of locating a new principal. And so there were 5 of us interviewing for that job. So all I had to do was have an interview with the dean. And I got in right after that.
Okay.
And I was replacing someone who was not certified in that particular aspect. I'm one of my certifications is vocal music education, and the teacher was not certified in music. So I was able to get the job.
Good. Okay. So one of the purposes of this particular part is to give you the interviewing process from behind the desk. You are now the person who is doing the interviewing as opposed to being the interviewee, and also providing some, what I consider to be some best practices. And I was so pleased to hear panel interviewing, because that's really a definite best practice. To start with, you should always wait before announcing an appointment, or excuse me, an opening, until there's a board action identifying that there's an opening through a vacancy, through a new position, or some other reason for needing this hire. The reason you should do that is you don't want to get out there and start a retirement, for example. This is a good example. So you hear that Joe is retiring, and so you say, special education are hard to find. I'm going to tell people about the job and let people know about it so we can get some interest. And lo and behold, Joe doesn't retire. And all of a sudden, you are sitting there with a little egg on your face, so to speak. So you want to make sure that the position is available. The other thing that I probably should say, even before I start all this, is that in an interim or intermediate level administrative position, you are always following the direction or guidance of your upper management, your supervisor, your superintendent. they set the parameters in general, and you are a player in that process. So you're always going to want to make sure that you really, really know what the expectations are with you and your role, and follow those kinds of things. So, after you've done that, after that's been done, that there's definitely a need for a new position, it's always a good idea to decide for certain exactly what we need. And I'll use myself or I'll use a situation I was in as an example. We had 2 high school business teachers, both who were teaching about 30 students a day. That's not very many. And one of them opted to take maternity leave for the year. I told the principal, we're not replacing this person. You're going to have to redo the schedule so that the one business person will be able to have all of these students. The one business teacher, the one who stayed, half a day she was spent supervising office assistants. I mean, come on, and so you have, and for those who have had me, Angela's had me, and the Walls have had me in finance, that, keeping eye on the dollar is extremely important. And that, that act alone saved my district about $60,000 that year. And we didn't impact education hardly at all. And so therefore, it's always good to have that conversation. Of course, you're going to get around to advertising the position, and which can be done a variety of ways. Sometimes you don't even need to advertise. My school was a small rural school. When we had a position of a high school secretary, the word got out on the street, and I'd have 30 applications on my desk the next day. However, special education was a whole different ballgame. When we were looking for special education teachers, we had to go through university sources to try to locate and secure a person. Always keep in mind that those advertisements should have the label EEOC, or Equal Employment Opportunity Commission, realizing that letting people know that you would be looking for or honoring equal opportunities. So when the applications come in, and once again, this all kind of depends on where you're at in your situation, but you want to paper screen the applications. You have a set of criteria that you're looking for, and then you look at those applications and decide whether the individual meets the basic expectations for the position or not. You can rule out a certain number of people and start to be selective in who you call for interviews. You already heard I'm a strong proponent of panel interviews, because it is always a good idea to get perspective from a variety of different people. The one that I'm proud of is hiring a music teacher, a band. It was an assistant band director at the high school. Well, I don't know anything about the band. I watched the band. I was actually in the band for a while, but as far as leading and guiding a band, I don't know anything. So we invited the vocal individual and the band director to come in with the principals, and we sat down and chatted about that. The one thing that I always made sure of, first of all, we had a structured interview. All candidates were asked the same questions. That's a key, in my opinion, in best practice. Ask them all the same questions. You can ask some follow-up questions that maybe deviate a little bit, but in general, same kinds of questions. And ultimately, you are conducting this. So when we did our review, and we tried to do that review, we tried to schedule our interviews on about an hour basis. The interview would usually take about 45 minutes, and we try to have 15 minutes to do a checklist and to come up with those kinds of things. When the interview process was over for the day, then we compare our thoughts. I made a point to not give people my view first. As the superintendent, if I just said, well, I think we should hire such and such, what do you think is going to happen? Most people are going to say, yeah, that's a good person. So don't do that. The other thing that we would do when we brought people in for this panel interview is we would always give them some sort of test related to their job. And one of the cases that we wanted you to be aware of was Griggs versus Duke Power Company. And what this company was doing was they were actually making it very difficult for minority candidates to get hired. They were using a method to rule out. You can't do that. That's obviously illegal, and that was determined to be illegal in the Griggs versus Duke case. What you can do, and I suggest it, is to give candidates some sort of test. For teachers, when they arrived, we always hope they arrived 10 or 15 minutes early for the interview. We would ask them to write a letter talking about an upcoming field trip. And they would submit that letter. We just wanted to see if they could communicate on paper. The one that we found to be most interesting was high school secretary. We asked the high school, when we were interviewing for high school secretary, we asked her to do some specific computerized kinds of work, primarily because we were going into a computer system. EMIS is what it's called in Ohio. So that's a management system, and the secretaries are the inputters of that information, a good part of their job. One candidate who was a good candidate, basically, she took 3 times longer than anybody else. Well, that told us this is a high-powered, high-packed job. It was going to be a challenge for her, and so we didn't offer her the position. So you can do that, and like I said, we did for any one of our occupations or job classifications. We gave them a related test to see what they how they would handle certain kinds of things. Okay. Once again, when you're done, you start to debrief. You start to ferret out the ones that people aren't interested in, the ones that they like. Eventually, come to a consensus on the individual who's the top candidate. And at that point, you still want to have a 1, 2, and a 3, because the number 1 might not pan out with the background check, which means you got to go to 2. And so therefore you always have a backup for that. One of the things I found interesting is that in a recent Michigan Supreme Court ruling, it created a new authorized user approach in gathering access to personal identifying information in court records. This approach went into effect on April 1st, 2022, and attempts to balance the need to protect individuals' identities with the need of background to gain access to verify someone's identity, et cetera, et cetera. So that's the balancing act, is privacy versus getting information. Obviously, as we already mentioned, make sure that throughout the process, if you are in the role as being the lead at a school building, for example, make sure you're keeping in good contact with the superintendent, and he is keeping you informed as to the direction. In many places, the principal has complete authority and takes complete authority of it. In other instances, the superintendent will be a part of the whole process. So it just kind of depends. And although I'm giving you these ideas, follow the superintendent's advice versus these ideas. Don't say, no, my school laws guy said have panel interviews. I want to have panel interviews. Well, if he doesn't want to have a panel interview, I say don't do it. But although it's really a good thing. Obviously, that you guys got around to this, someone offers you the job. That's again, and I found it interesting I think Nawal said that the principal offered her the job, but HR offered her the contract. That was pretty interesting. I never heard it explained quite that way, but it's very, it's very, very good idea, to do that. And so by that time, you start to get that person. And so from there, someone's going to take this to the Board of Education, and they are going to present them and recommend them for hire. And so consequently, and that's of course after fingerprinting, positive background checks. Also, you have to have the U.S. citizens' right to work, federal I-9 form. Maybe you guys remember signing that form. You have to have all that information in place before the contract can be signed and information ready to rock and roll. And then you start to onboard that individual. So through that process, did anything surprise you that you hadn't thought of before? Okay, so we'll move on. We'll move on to the next one. The second one is to identify the protected class of citizens as well as the related major federal anti-discrimination statutes and cases. Who can give me one of the, I think there's 6 classes. Can someone give me one?
Ethnicity?
Yes, actually they clump them all together: race, color, religion, creed, national origin, and ancestry. Okay, and what is the legal aspect behind that? There's about 3. There's 3 legal sources behind that, those protections.
Isn't one the 14th Amendment?
Yes, absolutely. The 14th Amendment, equal protection of these individuals. Okay, for certain. Another one?
Would Title 7 from
Absolutely. Title 7, and that's the most recent. Amendment 1 is also kind of clumped in there, particularly about religion, of course. And so we classify that together. But Title 7 is the most recent one, although there have been some additional things come up after that. Okay, what's the second protected class of citizens?
What is this, Title 11 and sexual harassment?
I'm sorry?
Oh, is that Title 11 and like sexual harassment? No.
Okay, you're on to something there, but right now we're just trying to get the classes.
Oh, okay.
So what class would that be in? What class would need protected?
Gender.
Bingo, gender, and that's Title 9. Actually, you had your I and your X turned around there. Title 9.
All right.
The Pregnancy Discrimination Act, and also Cleveland Board, and basically the Pregnancy Discrimination Act says you shall not discriminate against pregnant individuals. The Cleveland Board of Education versus LaFleur was very landmark breaking, because before this particular case came before the Supreme Court, school administrators could tell a pregnant lady, don't show up to work anymore, maybe after the 2nd month, 3rd month. In fact, amazingly enough, I had this individual in my class one time that said this happened to her. I said, wow, I don't know what to say. I mean, sorry that happened to you. But after Cleveland Board of Education versus LaFleur, pregnant employees must be permitted to work if they are able to perform their duties. Now, you see how that's a landmark decision? Think about that. Before then, administrators could say, you're done. After that, no. So that's landmark. Okay, so you got 2 of them. What else we got that's protected?
Age discrimination,
Age,
employment.
yes, age discrimination. The thing that always surprises people is the age is 40. And so anyway, so yes, and it speaks for itself, you know, obviously. And the only thing I'm going to say here is that if a person is older and they can't perform the duties, document that they can't perform the duties and don't tie it to their age. If you tie it to their age, you got a problem. And one of the things that I always tell my law students is you ain't got a problem till you got a problem. And therefore, you know, you don't want to tie it to that. And you've already learned about the Open Records Act and so or Public Records Act. Therefore, if you tied it there and somebody asked for the records as to why you made this decision, and lo and behold, you said because of their age, oh my gosh, you're going to court. More than likely, and sounds like the evidence would not be good in your favor. What else do we have?
The disability.
Yes, mental or physical disabilities. And can you remember the cases or the statutes there? Actually, it's statutes.
Not really. I'm not.
Anybody? Americans with Disabilities Act is the most recent, and the Rehabilitation Act, Section 504. Now, the thing you have to hear here with the Americans with Disabilities Act, basically what that legislation stated is if you, and this is throughout the entire hiring and employment process, you must offer reasonable accommodations to individuals who present themselves with disabilities. You must always provide them reasonable accommodations. Now, if an individual is in a situation where they need to have the best way for me to phrase this is if you had to put an elevator in a building to employ this person, most situations would say that's not reasonable. Now, just to give you some of the interesting things you get involved in with administration, one of my principals called me one day and they said, Doc, I have an individual who's a substitute teacher who's blind. What do I do? And I went, oh my gosh, what do we, well, I know what we don't do. We don't discriminate. I know that. And so we aren't going to discriminate. And I said, okay. I said, how did it go? Well, it was okay. I said, okay. So I said, from now on, if we need to use that person, bring in an aide to be with her. I think it was a female. Bring in an aide to be with her. And so we provided accommodations in that way ourselves, unbeknownst to her, actually. Okay. I think there's two other ones. One's very obscure, very obscure. In fact, it surprised me. Genetics. Title II of the Genetic Information Non-Discrimination Act of 2008 said you cannot use genetics you cannot discriminate against genetics. Now, I'm not a genetic knowledgeable person, so I can't speak much beyond. I'm just telling you what that law says. There's one last one. And this is in Michigan, by the way, not federal yet, although it's in many states. LGBTQ. In Michigan, you may not discriminate against LGBTQ individuals. Once again, not national, federal, many states do have that protection. Okay, so that is the basis of the discriminations. Talk to me about the elements of a legal contract. What are the elements of what parts, and what's interesting is when you signed your contract, you went through these, didn't even know it, probably. But now you'll know.
Would the first one be the offer?
Yes, you have to have an offer. I mean, you don't have a contract if there's no offer. And coming along with an offer is
Acceptance.
acceptance, exactly. What else do you need?
Awareness.
Well, legally competent parties.
Mhm.
If one side is deemed not to be competent, mentally particularly, that contract would be out the window, so to speak. So they have to be legally competent parties. You have to have legal substance. You know, when you signed that, you probably didn't read it, but in it, it spelled out your duties. It talked about certain kinds of things, and you signed it and was happy you got it, and went from there. So therefore, it becomes legal subject matter with competent consideration and in a proper form. Okay, so those are basically the parts. Now, I'm going to guess that about 4 of you are probably at-will employees. You have at-will contracts. Am I correct?
Yes.
I'm saying Ezra is at-will. I'm saying that Lanice is at-will, Carice is at-will, and Angela just got out of the at-will employment business and got into a contracted business. And one of the Noels, I think, is at-will, and the other one I think is not. Maybe both of you are not, I'm not sure. Okay, so we got that we understand what sadly, you know what at-will means. You have no protections, or very, very limited protections, let's put it that way, as opposed to an individual who has a contract. Angela, are you on a probationary 1-year contract?
Yes, I am.
Yes, that's the typical beginning contract, is a probationary 1-year contract. Now, what that means is that if you fulfill your duties, then you have a property right to salary under that contract. They can't take it away from you. They've got to provide that salary for you, okay? Anybody else on a probationary contract? I think Michigan, in Michigan, I believe it's 2 years under a probationary contract. In your 3rd year, you have a continuing or tenured contract.
So I'm not sure if at Dearborn Public Schools it's 3 years or 5 years.
Oh, okay.
I'm almost certain it's 5 years that you're on probation.
Very well.
I'm almost certain because they don't count you as a tenure until 5 years have passed.
Yes, very well could be. This is something that I'm not necessarily that cued in on. In Ohio, we offer called limited contracts, and limited contracts can be 1 year to 5 years in limit, and then there becomes a threshold where you become eligible for tenure. And of course, most people know what tenure means, right? Can someone tell me what tenure means?
Isn't that almost like something where somebody's like grandfather in?
I'm sorry, say it again.
Is that almost like something where somebody's like grandfather in?
Well, I don't want to use the word grandfathered, but you have continuing employment. So you're not necessarily, grandfathered means it came before you. And this means when you got the contract, it continues on.
Okay.
It does not have to be renewed. It's just automatic. It's automatic until actually the employee chooses to, or there's a termination. So the last one is supplemental contract. And have you had a supplemental contract before? Angela, I'm sure you did.
I had it both as a coach and also as a senior moderator and in charge of the yearbook.
Yep. All of those positions are supplemental, meaning that they're above and beyond the regular contract. Okay, so that's the contract types. Okay, now let's talk about the U.S. constitutional amendments related to staff rights. which amendments and what rights are referred to for staff?
Oh, wouldn't the 14th Amendment would be right for equal protection?
Absolutely. 14th Amendment, equal protection and due process. Both of those items, equal protection and due process. Someone give me another one? How about the First Amendment? Free speech, right? That's free speech and expression, free speech and expression. The Fourth Amendment, that's searches. And the one that people don't realize is the Ninth Amendment. And the Ninth Amendment is privacy. It's kind of one of the lesser known amendments, particularly with regard to employment and staff rights. So now we're going to get into Module 4 objectives. And I know you haven't had a lot of any time probably to look over these resources. And I really encourage you to take the time to look over those, particularly the video, because in the video I go over extensively the cases, and we'll go into even more cases than what we'll discuss tonight. Tonight I'm going to give you the landmark cases, the most important cases. And as I give you the information on these cases, I want you to listen to how I present the case, okay? So the objective is to identify the landmark federal cases that have interpreted the Bill of Rights in a public entity and understand their significance. And the very first one is Pickering versus Board of Education of Township High School District. Has anyone had a chance to look at or hear of that case? Okay, so the legal issue in this case, legal issue is freedom of speech. The legal question is, was Pickering's letter constitutionally protected free speech? Here are the facts of the case. His school district was involved in a levy campaign. And in his opinion, the board and the superintendent did a very poor job in managing the levy campaign. Therefore, he wrote a letter to the editor complaining or criticizing the board and the superintendent. Now, this was in, I think, the 60s. Before then, nobody had at least presented critiques of this nature, I guess. Well, he got fired immediately. Fired immediately. It goes to court and ultimately ended up at the U.S. Supreme Court. And the Supreme Court found in Pickering's favor because the letter's content was public concern. He wasn't speaking about it for himself. He was talking about for the community, that he was basically saying that they did a poor job and the community was going to be harmed because they did a poor job. So that was one of the very first cases, educational type of cases. The second one is Connick versus Myers. And in this particular case, the legal issue is again, free speech and expression. The legal question is, did Myers have a free speech right when she distributed a questionnaire in the office? Was her speech constitutionally protected? And although this case occurred in the prosecutor's office, you need to understand that this is relevant to school law because it occurred in a public entity. And therefore, we draw precedence from those kinds of situations. Here are the facts of the case. Sheila Myers worked as an assistant district attorney for over 5 years when her boss transferred her to a different section of the criminal court. Myers strongly opposed this transfer and made her feelings known to several supervisors, including District Attorney Harry Connick Sr. You heard that name before? Harry Connick? This is his dad. This is the singer's father. You know, the other thing that I always like to point out, to students is these cases involved real people who had real feelings and real circumstances and sometimes maybe went through some bad times as their cases were going through courts. So before the official transfer took place, Myers prepared a questionnaire asking her coworkers' views on the transfer policy, office morale, and the level of confidence in supervisors. Harry Connick Sr. told her, do not distribute this questionnaire. The court ruled in favor of Connick. The questionnaire was restricted free speech because it was private concern. She only was doing this because she did not want to be transferred. And the court said, they didn't restrict anything. I've later done some follow-up examination of where Connick is. I'm not sure he's still alive. He might have passed away by now. But I saw an interview of him, and he was saying, you know, I didn't even think this was a free speech case. He said, she disobeyed our order. He said, for me, that was the issue. She disobeyed our order. But the court saw it as a free speech case, and you know, we won it. And she ended up becoming a professor in the College of Law, I think at LSU. It was all taking place in Louisiana. So real people. The next one is New Jersey versus TLO, occurred in 1985. And the timing of these things kind of becomes important because it puts a context behind the circumstances. So in this case, legal issues, searches in school pertaining to the Fourth Amendment. The facts of the case. A principal caught 2 students smoking. One student admitted it, but TLO denied smoking. The principal proceeded to search her purse, looking for cigarettes. When he searched her purse, he found a pack of cigarettes, cigarette rolling paper, a plastic bag containing marijuana, drug paraphernalia, a wad of money, a piece of paper with the names of students who apparently owed her money, and a letter that appeared to implicate TLO as dealing marijuana. So wow, did he hit a treasure trove of stuff. Okay. He suspended and probably expelled her and turned her over to, she was 14, turned her over to the juvenile court system, and they took action, whatever. Well, obviously, and oftentimes people don't realize this, but certain groups support these cases. And ACLU, American Civil Liberties Union, is one of those associations that often promote or encourage and support cases that are kind of pushing the boundary, so to speak. So the question, of course, is, did the principal do a proper search? And the Supreme Court held that the Fourth Amendment applied to school administrators' actions. So they have to abide by the Fourth Amendment. However, the court ultimately determined that his actions in this case did not violate her Fourth Amendment rights due to the need for school authorities to respond immediately to safety threats and to protect the education environment. Because of this, PK-12 education justifies a special exception from the Fourth Amendment. And of course, the Fourth Amendment, as you probably will maybe remember from your civics class, police officers have to have a warrant and probable cause to conduct a search. School officials do not. All you must have is reasonable suspicion. So if you suspect that a student is doing something wrong, and it could very well hurt the safety of others, you have every right to pursue that via a search, okay? The one thing that you need, so I've worked with a lot of students in this, and some students will say, well, I'll let the resource officer do the search, primarily because they're a little timid about doing it. You can't do that because the police officer, the resource officer has to have a warrant. You don't. And so, okay to have the resource officer behind you, but you need to be the one who is conducting the search. Now, this actually pertains to students, of course, and may not necessarily apply to staff. But I like to bring it up because it starts to set the stage for the next one, which is which is called O'Connor versus Ortega. And in this particular case, the legal issue again is searches the Fourth Amendment. The legal question, did the supervisors search the office of Dr. Ortega's and violate his reasonable expectation of privacy guaranteed by the 9th and 4th Amendments? Here's the facts of this case. In 1981, officials at a state hospital, once again, public entity, state hospital. If it had been a private hospital, different ballgame. But it was a state hospital. And one of the officials was the executive director, Dennis O'Connor. They suspected improprieties in his management of the residency program. The officials conducted an investigation of Ortega, which included multiple searches of his office and the seizure of a number of items. The items were later used in proceedings before the California State Personnel Board to impeach the credibility of witnesses that testified on Ortega's behalf. The ruling, in a 5-4 decision, the court held that the search did not violate the Fourth Amendment. The court held that the realities within the workplace made for expectations of privacy among public employees unreasonable when the intrusion was by a supervisor rather than a law enforcement official. Work-related searches, the court found, were merely incidental to the primary business of the agency, and a warrant was not required. The court held that a standard of reasonableness was sufficient for work-related intrusions by public employers. So they had evidence of the improprieties. They submitted that evidence. They said, here's the reason we conducted the search. Here's what we found. It substantiated our concerns, and he was probably fired. The next one, we got a couple more of these. The next one is Erb versus Iowa State Board of Education. The legal issue here is personal privacy, 9th Amendment. The legal question is, can the state revoke a teaching license due to an affair? Here are the facts of the case. Richard Erb had an affair with a coworker. When the affair became known, the state revoked his teaching certificate. Erb brought a legal action against the State Board of Education, alleging the action was illegal. While the case was proceeding to the Supreme Court, Erb offered to resign his teaching position, but the local school board unanimously decided not to accept his resignation. The board president testified Erb's teaching was highly rated by his principal and superintendent, and that there was no nexus or connection between the affair and his teaching performance. That was key, the nexus, connection. There was no nexus. He did not lose respectability from the students. He did not lose his edge as far as his teaching skill, and they retained him for the school year, and he continued to teach. The ruling from the court, they upheld Erb's complaint, and his teaching license was restored. This next one is not in the Essex book, and I just absolutely cannot believe it because it is so important. It's called Cleveland Board of Education versus Loudermill. The legal issue here is due process. And in particular, we're looking at the protected interests of life, liberty, and property rights in the 14th Amendment. The legal question: can a state remove a civil servant's property rights, the right to salary, to employment before providing an opportunity for that worker to respond to the charges against his termination? Here are the facts. James Loudermill stated on his application for employment with the Cleveland Board of Education that he had never been convicted of a felony. After hiring him as a security guard, once again, this was in a school board, so not only teachers, but other staff members granted rights as well. The board discovered that he had been convicted of grand larceny and without further consideration fired him immediately for providing false information on his application. You don't have a problem till you have a problem. Because Loudermill qualified as a classified civil servant under Ohio law, he obtained or had a property right to his employment. This meant he could only be dismissed for cause and could obtain and should obtain an administrative review of causes before his termination. The court ruled in his favor. So although he did wrong and wasn't honest, the school didn't provide the proper process. And so the court ruled in Loudermill's favor, and it was granted his job. And here are the mandates that came as a result of this. First, there must be a notice of intent before job action. Now, when we talk about job action, we're talking about a dismissal, a suspension. Those are the primary biggies for job action. Could be a reprimand, I guess. There has to be a hearing to ensure fair play and protect the property rights from arbitrary encroachment prior to the action. An impartial tribunal must judge the evidence without prejudice. The individual has a right to counsel, of course. They have a right to confront and cross-examine witnesses and the information. So see how before then, school administrators could fire people and there was no, and probably many were, but nobody maybe took action. But in this particular case, action was taken, went all the way to the Supreme Court, and they defined exactly what must be accomplished. These are some of the things that boards of education do not understand when they get hired or when they get elected. They think they can fire people at will. You better not do that. This next one is one that has personal meaning to me. Here's why. It's called Barrett versus Steubenville City School District. Richard Lucci, in his individual capacity as superintendent. This case, after a staff rights session, just like this one, although it was face-to-face, student comes to me and he says, "Doc, I got a question for you." Told me a situation. I looked at him and I said, the only thing I'm going to say is you need to contact an attorney. Here was the issue. Privacy in rearing your children. The legal question: can a superintendent withhold employment to an employee if they do not move their child into the school district? Here are the facts. Barrett applied and interviewed for a teaching position in Steubenville City Schools. He was told at the time that he was the best candidate for the position, but he must remove his child from the parochial school and enter him into the public school before he would be granted the job. And by the way, this had been past practice at Steubenville for years and years and years. Patrick finally took him to court on it. The circuit court ruled that the board itself was granted sovereign immunity. You'll learn about sovereign immunity a little bit later. However, the superintendent was found to have violated Barrett's parental rights. Barrett's parental rights. He later shared with me that he was given a financial settlement, although the attorneys took a lot of it, he told me, He did not get that job. He worked for a while at an academy and is since not in education. I'm sad about that because he was a fine young man and would have been a good administrator. DeMarco versus Brown is another one. This is a 21st century one, so that's the reason I bring it up to you. Legal issue is privacy again. Legal question: can a sexual picture on the internet that is unknown to the person be used to terminate an employee's contract? Here are the facts of the case. The teacher was at a bachelorette party when someone took a picture of her with a stripper and put it on Facebook. When school officials, and she didn't even know it. She didn't even know it was taken. When school officials learned of this picture, she was fired. In this case did not go to court. There was an out-of-court settlement. And in lieu of her losing her job, she did get her job back. She did lose some pay as a result of it. And of course, embarrassment and all those kinds of things. But that happened. So I also provide you in that video a couple of other 21st century cases about blogging and how you can get yourself into some trouble if you're a blogger. Okay, so once again, make sure you take the time to look at those other cases there in student rights. So those are the really important staff right cases that change the way we do work. So we want you to know that. Distinguish between protected and unprotected educators' speech. Now, you might be able to guess this. What would you say would be some of the unprotected speech? What if someone's harassing somebody? That wouldn't be protected. What if somebody threatens somebody? Not protected. If they're defaming somebody, of course, defamation is kind of tricky to determine, but in general, it's not protected. Obscenity, not protected. Child pornography, not protected. Fighting words, not protected. Based on that, most other speech would be protected speech in general. Now, once again, go back to Connor, and if you are trying to do something for your personal gain against an employer, might not be protected. Okay. So now we get into some of the other employment laws other than discrimination. Some of these I'm guessing you may know about. Okay. So if you know something about them, let me hear. Okay, because they're fairly common. Of course, we already talked about the Americans with Disabilities Act, and of course, the importance of reasonable accommodations. And so and once again, all of these go from hiring all the way till you separate from employment. Okay. How about the Family Medical Leave Act? Have you heard of that one? Has anyone had the opportunity to use that?
Is that the FMLA?
Yes, FMLA. Can you tell me what that is?
So because we have it our
what you know.
our school, but I wasn't. That you can use it if you're out of school for either taking care of family or for your own medical, and it won't be used against you for like hire or evaluation.
Yes.
So the time off is not used against you. If you have days off, they pay you.
Yes.
If you don't, then it gets deducted, but it can't be used against you.
Yes. So
Something that I use as well.
I'm sorry.
It's also if like for maternity leave. Like for me, for instance, when I delivered my baby, I was under FMLA. They would give me 12 weeks. It was unpaid, but I have up to 12 weeks and it wouldn't count against me.
Yes, exactly. And so consequently, FMLA can also be used for your parents, for example, to help your parents in a situation they need help and you need to be there. I'm not sure how far that extends to other relatives, but that's, you've nailed that on the head. Okay. This one The next one's pretty simple to understand, Equal Pay Act. Equal pay, right? Okay, it's all about, obviously, there's always been a disconnect or a difference between male pay and female pay for the same occupations, although we are gradually getting closer and closer with those kinds of things. I'm very proud of the fact that in our profession, on average, there is not a disparity. You know, you typically have a salary schedule based on not based on your sex, but based on your years of previous employment or years of employment, your education level, and those determine what you're actually paid. So the Equal Pay Act is on the books. Another one that you may have heard of is Occupational Safety and Health Act, known as OSHA. Anybody have an idea about that one? Well, this requires entities, businesses, schools to provide a safe work environment. And once again, you know, the intent here is not to necessarily get you deep into understanding all the particularities of the OSHA Act, but just begin to introduce you to the Act and understanding the overall part of it. You know, one aspect of the OSHA Act, none of you are science teachers, are you? So, you know, oftentimes if you're teaching particularly a high school science and there's a lab, there might be some chemicals. Well, you've got to make sure that you contain those chemicals. And there's also lists of the kinds of things to do, what happens if something occurs. So that's just a very minor part of OSHA, but it is an element of OSHA. And schools for the longest time were not impacted by OSHA, but then they now are definitely impacted. How about, I'll say the long name and then I'll say the short name and might trigger you. Consolidated Omnibus Budget Reconciliation Act, known as COBRA. COBRA. Not heard of it, huh?
That's about health plans and beneficiaries, isn't it?
Bingo, bingo. And so, yes, and not, you know, hopefully you understand that knowing this information is kind of helpful on a personal note as well as professional. So what COBRA is this: if you become separated from your employment for whatever reason, doesn't matter, whatever reason, they have got to provide you continued health benefits. I can't remember how long they're continued, but they are continued for a while. Now, you have to pay, I'm sorry, Angela? Oh,
I believe, because I just went through this, they have to give you 30 days past the last date of your employment. And then after that, you have to go on to COBRA.
yes. But I'm not sure how long COBRA lasts. COBRA might last for 12 months. I can't remember that. But, and so exactly that. Now, here's the catch is you have to pay for those benefits yourself, but you are offered those benefits, okay? One that gets in the news kind of often lately has been the Whistleblower Protection Act. Anybody have a clue or know what that is?
I mean, I imagine it's probably like when you reveal something, bring something to light, you can't be, I don't know what the word is, retaliated against.
Yes, you can't be punished. You can't be retaliated. So exactly that. So you work for an organization, something is amiss. You decide to go to authorities and reveal what is amiss. You may not be retaliated against. They don't even have to know who you are. You are protected from the Whistleblower Protection Act. And typically, not only is there a federal law, but there's also typically a mirror or a similar state law. I think I saw that in Michigan. Okay. The next one is one that is a little less known, but is pretty impactful. if you are, have been in the service or in the service, Uniformed Service Employment Reemployment Rights Act. That might be, anyway, we'll go with Uniformed Services Employment Reemployment Rights Act. So
It allows them to get their jobs back after military service is complete.
yes, so if a person is in the military, we'll say the National Guard, they are teaching and they are called to duty. When they come back, and it doesn't matter if that duty is a year or 2 years, when they come back, they must be offered either that job or a job similar with the same pay, et cetera, as to the one in which they left. So we're protecting those who are protecting us, so to speak. Okay, and throughout that conversation, we heard from individuals who were aware of many of these kinds of things because they've experienced them, and that's good. Some cases, I'm glad you haven't had to experience it yet, but be alerted that if you are there, these are on the books for staff members. Okay, so any questions about this content to this point? Once again, so to give you a way to cut through some of the aspects of Module 4 activities, watch the PowerPoint. It's about 20 some minutes long, I think maybe 25 minutes long. It will go through a number of other cases that are related to the First Amendment, the Fourth Amendment, the Ninth Amendment, the 14th Amendment, et cetera, et cetera. And although they aren't as impactful as the ones we discussed, they still have some good pertinence for you to know. So before our next Zoom meeting, you're going to have a couple of things that you're going to need to do. Okay, the first thing you're going to need to do is you are going to be doing an official reprimand. So I think it's next week you start to talk about disciplining and dismissing a staff member. And so therefore, you will do that. And you will also be completing a case study. Of course, remember that tomorrow night, Friday night, you have to do your thread of discussion. And then on Monday, it will be the quiz. It'll be from 6 until 10 will be available. You will also have a case study. Now, what a case study does, it takes a situation. As I mentioned to you, legal situations don't happen in a vacuum. They don't happen one at a time. Sometimes they're simultaneously going on in concert with other kinds of things. So we give you a case. In this particular situation, it'll be dealing with, I think, cases or modules 1 through maybe 5. I can't remember exactly. And you'll report that case. Here's the format that you're going to use. Okay. So what you're going to see here is you'll read the case. And as you read what I try to get you to do is I'm trying to get you to, when a situation's happening to you, I want you to say, legal situation, flags go off, and hopefully you'll be able to recall some of the proper actions. So in this case, you will identify the situation. What is the legal situation where the bells start to go off? What's the legal issue? And you heard me going through those cases. I was citing legal issues, okay? Sometimes the legal question, and then the citation. What gives us the support to take appropriate action? And in some cases, you'll find that what's being done is legal. And in some cases, you'll find out that what is being done may be illegal. And so you will just say, this action is marginally legal, for example, and you give a rationale with that. And you just list the 5 or 6 different situations that are occurring in this case study. Okay?
So you'll give us the case studies and then we just have to put the situation,
Yes, the case
legal
study,
issues.
yeah,
Okay.
the case study hopefully will pop up. It should pop up next week, I think, and be ready for you to take a look at. And then you can start and just put this together in a Word document with a table. Okay. And once again, we have an example in there for you as well. Okay. Question.
Dr. Bourne, I have a question for you.
Yes.
Would it be possible to, instead of having the modules and the assignments pop up like during the week, would it be possible to have them pop up the weekend before? Because I know, like, for me as a teacher, I like to do my work on the weekends ahead of time because I'm so busy during the week.
Okay.
Would that be possible?
So I'm
That's
trying.
something I wanted to ask too. And like with the discussion board being due on Friday,
Yes.
it's so hard to keep up with everything and have it done by Friday. So if we can have them lay out a week in advance, it
So
would be very helpful.
I think I've addressed the discussion. You know, today when I discovered the issue that I was telling you about, that things weren't popping up like they should, I said, "Oh my gosh!" And I went and looked, and here, yes, the actual title came up, but the objective nor the activities weren't popping up. So I went back and figured out how to make sure that they popped up. So I think it will take care of itself, because I have these set up so that they pop up 2 and 3 weeks ahead of time. That's what they're supposed to. It's not supposed to come up like like this one did after. This one was supposed to pop up last Monday is when this one was, not this Monday, but last Monday. So I think it will take care of itself. If it continues to be a problem, let me know. And the same thing is true with the thread of the discussions. Those should pop up. Actually, in fact, when I set those up today, if we were looking at the discussion for modules 10, 11, and 12, I set it up for the start of the first day of the module 10. So give me some feedback if this week, if it doesn't pop up in time, let me know and I'll reevaluate. And yeah, I don't have any problem with those popping up sooner if necessary. But I think that it will take care of itself. I'm just not sure yet. Okay.
And is there any way that the discussion board can be due Saturday night instead of Friday night?
Yeah, I was gonna ask that as well. If we can push the due date to the weekend instead of
Yes.
during.
I don't have, the only, yes, I have no problem with that. I'll make that change. That's no big deal. And I understand exactly what you're saying. I realize that, having, working 80 hours a week as a superintendent and doing my doctorate program, time was of the essence. And you're right, the time that you had to do that was primarily on Sunday, practically, maybe some on Saturday or Saturday and Sunday. So yes, I will go ahead and make those that problem. I mean, it's not a problem. The big thing is I just want to make sure that people have time to look at those. And by the way, with the reaction, all you have to say is on target, partially on target, and tell me why, or not on target at all, tell me why. But other than that, you're doing good with those. Okay. So we'll see you later. Good luck on your quiz.
Thank
Look
you.
at that PowerPoint. Or actually, it's a YouTube. It's actually a YouTube video.
Dr. Bourne, can I stay after everyone leaves? I just have a question about the last assignment, something that I
Yes.
wanted to clarify.
I'm gonna stop recording now. So
Thank you.